A little after 10:15, and I apologize for being late, but we had some other business we needed to have some discussions on. I'm going to call the House Judiciary Committee to order, and as the first order of business, would you please stand and join me in the Pledge of Allegiance? I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. We have a number of bills to exec today, and there are some of those that are on the schedule for execing. I believe we're just not ready to exec because there are either amendments or other issues that have to be discussed. Since I know that House Bill 1283 is a bill that has generated, probably more attention than any others, I guess I would like to introduce that first as something to talk about, and guess I would recognize Representative Smith if I could on that, please.
Thank you, Mr. Chair. And I look out, and although I never wear badges or symbols I see a lot, and I know many people are here for this particular bill, but I have a problem that I'd like to raise. Members of the committee have identified several amendments that they would like to have considered on this bill, but none of the amendments have been able to be presented to us yet. So I'm concerned about our moving towards voting on a bill where we don't have all the details yet. And I know how disappointing that would be for people who have traveled here, and we honor their commitment to the issue, but think that I would suggest that we put off discussion and eventual voting on this bill for till next week, when we have already posted that we would deal with the bills we couldn't deal with today. I believe that's next Wednesday afternoon on the 21st. Is that correct?
That is correct. That is correct.
Thank you.
So I guess what I would say is this, and I want to hear from what other people have to say about this, but my inclination is that Representative Smith is correct, and that would be my inclination of what to do also. And I just to put a little more detail in that, among the amendments, people who were here at the hearing may recall that there was some testimony. We heard from I believe, two representatives of pharmacists as to whether or not they should be included in the bill, and that seemed to make sense as I tried to go through the bill line by line. I'm not completely convinced whether we need to put them in there or not, in terms of what would make the most sense. But that's one possibility that I think we need to think about more carefully. And the other, just a couple of other examples. There has been some talk about whether or not, right now the bill contains, among the people that can be healthcare provider are included an advanced practice registered nurse license pursuant to RSA 326B, and a physician's assistant license pursuant to 328D. And there's been some discussion about whether it's appropriate to include those individuals, or should it just be limited to, should physician's assistant be removed, or should physician's assistant and advanced practice registered nurse be removed so that it would be limited only to a physician or an osteopath? The other thing that I discovered is that there is some, I think there may need to be some cleanup, for lack of a better term, of language in the bill. For example, one of the terms that's defined in the bill is healthcare provider, and I'm sorry. One of the terms that's defined in the bill is prescribing healthcare provider, but later in the bill, that the term attending physician is used, or attending provider is used, and I don't think that my impression is that that was not intended to be a substantive change, but as somebody who has worked with language in my past life, I understand that sometimes they're using different words when you mean the same thing can be a problem. So that might be something that needs to be looked at also. So for those reasons, my inclination would be that we are not ready to vote on 1283 today. That's my inclination. Do other people have any other view? Representative Alexander.
Thank you, Mr. Chair. I believe there are a number of members that may want an amendment or something to clean up what you said was deeply flawed language, but I think there are a number of members that are ready to vote on a deeply flawed bill today. So I'm happy to wait if the committee decides that, but I'm ready to vote today. Thank you.
All right. Yes, Representative Perez.
I know you mentioned a couple of the cleanup things, but I have gone through the bill as a healthcare provider, not a lawyer, as a healthcare provider, line by line. There's a lot more. Residence requirement, lots more. What the bill does for normalizing suicide for teens, there's a lot of words. What is reasonable medical judgment? There's a lot of cleanup that needs to be done. Whether you are for this or you're against it, the amendment itself, in my opinion, as a medical person for 42 years plus, the bill itself is flawed. I don't think there is anything you can do in a week to clean up this bill and make it appropriate for what we're looking at. And I'm ready to vote on it as well.
So let me, I guess what I just wanted to ask Representative Perez to make sure I'm understanding is, I mean, is there anything, you said you've gone through the bill, you've seen a number of things that need to be cleaned up. Are those things that you would propose amendments, or is your position that no matter what the amendments would be, you're still opposed to the bill?
I don't want to put in amendments on these things. I have no idea how to clean this up. I have no idea how to take line 20, reasonable medical judgment, and make that cleaned up. I have no idea to, coercion, how to clean that up. Provider must have health records. All the records since the person was diagnosed. There's a lot. I don't know how to clean up this bill. Okay.
All right.
I think the bill needs to, I'm concerned about what we want to do with this bill. I know a few years ago, people knew it was open up to other things. I don't know if this is similar to that bill, but I mean, does the bill need to be retained? I don't know if you can clean it up. And how I feel about it, I have two sides. I have the first generation Italian Catholic, and I have the legislature. I have not heard from one of my constituents that they want this bill. So that's the legislator side of it.
Yes, Representative Kinney.
Well, just on that, I've heard from a lot of my constituents that they would like to see a workable bill. I feel like members of this committee and people who came today will fall into two camps. They'll either be wanting ITL, no changes can really fix it for them. And then others who want the best product to come from amendments, because I think we all probably agree that an amendment is necessary if we were to go forward with it. So I'm not ready to vote on it today. I think many members of this committee wouldn't be ready to vote on it today, because an amendment could make it workable. And I think a lot of my constituents would like to see an effort to make this bill as good as possible.
All right. Anyone else?
Mr. Chair?
Yes, Representative
Thank you,
DiLorenzo.
Mr. Chair. Thank you for taking my question. Well, I believe that this bill is not ready for prime time. And it sounds like it would need a lot of amendments and a lot of work and a lot of time to get it to where it could be possible or palatable for the residents of the state of New Hampshire. And I'm thinking that maybe this should have been a constitutional amendment, a CACR, rather than just an LSR, because that way it goes to the question goes to the voters and they get to vote on it. Thank you.
Anyone else? Any other comments? Yes, Representative Stapleton.
Do it in a week.
Yeah, thank you, Mr. Chair. I don't think I've had another bill where I've had so many constituent and other inputs, hundreds of emails, dozens of letters on both sides of the issue. So I haven't made a count, but you know, if it's 45, 55, or 50-50 or whatever it might be, I have trouble with this bill from at least 2 points. The insurance, classifying suicide as not a suicide, represents problems for the insurance industry and life insurance contracts. I'm troubled with the lack of attendance, you know, self-administration. Many of my constituents are opposed to this from ethical, practical, and even moral standpoints, and so am I. And I believe that the amendments aren't going to change those basic holdings and beliefs. So I'm ready to vote on this now. I have experienced and been with close friends and relatives in the passing of their lives and have supported them as much as I could. And I was very satisfied with the state of palliative care and hospice. They know how to administrate the pain medications to the point necessary until the body gives up and systems fail. I am a believer in the sanctity of life from the moment of conception to the moment of natural death. And there are many hard stories that have touched the heart about pain and suffering. But I think we got to get this right, and self-assisted or physician-assisted suicide is not the answer. I think we need to concentrate on palliative care and improving that in education. But I would be a no vote on this bill in any case, amendments or no.
All right. Anyone else wish to be heard? Yes, Representative Alexander.
Thank you for listening to me again. I think maybe perhaps the best strategy would be for the committee members that would like to work on this bill, we interim study it and allow the members this summer to work on the bill, because it seems like not a single member is ready to vote yes on the bill today. Maybe from what I hear. So maybe the ones that would like to work on the bill, work on it over the summer, and then the ones that do not want to work on the bill and will not be voting for it, take the summer off. Thank you.
Anyone else wish to be heard? Yes, Representative Tur.
Yeah, I just wanted to say, you know, and I'll echo where Walt started. Representative Stapleton started. You know, if there's division on this and there are potential amendments that may or may not cure issues with the bill for some or more of the members, it sort of feels like, why wouldn't we finish that process first and get to a place where based on the things that people know they want to potentially change, that we can evaluate that and get. I don't think our goal is to get to the place where everyone's in agreement. It gets to a place where we all feel like we know what we would be voting on. So I would be supportive of continuing this and hearing those amendments and then voting, and seeing where we stand as a group.
All right. Anyone else? Representative Horgan.
Thank you very much. First of all, I lived through this issue in my own life just a few weeks ago, and I know all 19 of my colleagues on the committee have been thinking and praying for me, and I'm thankful for that. But I think regardless of what happens to this bill, we probably need to raise public awareness of the existing options for palliative and hospice care, which I think maybe not every family that's in crisis is what knows about some of the options that already exist under the existing laws. So even if we pass this today and it goes through, it's still like whatever the effective date is. So even then there'll be a period of time where people are going to be going through what my family went through. So I think this issue, I mean, certainly would be better to consider some amendments and take a little more time to look at it. But I think even regardless of what happens, I think there needs to be greater public awareness of what they can do for their family and friends when, as happens to everybody, they get near the end of life. So that's my 2 cents. So and also once again, thanks everybody in the committee and many of the people who are sitting in the audience too for their support. And I know we'll all need it. Well, the rest of us will all need that same support at some point. And I hope I'll be able to pay that back. So thanks.
All right. Representative Perez.
I agree. In any rate, to try to exec this in less than a week from today, I do not believe does it justice to be able to get the amendments in that people want and absorb the amendments and then not work on this until, towards the end of the day in a week. I think it's way too soon.
All right. So anyone else wish to be heard? Yes, Representative Smith.
This is what the democratic process, small d, democratic process is all about. It is listening to our constituents. It's listening to our colleagues. It's trying to find a way to get us to yes, whatever yes is, hearing disparate views. And it's never easy. And we don't always get it right the first time, I'm sorry to say, but we try. One of the thoughts that keeps on coming back to me is that in the fall, late fall, UNH, which doesn't always get things right either, but nonetheless, UNH ran an independent poll on this very issue. And when you look at the results, there are some really interesting numbers that come up. It's the data that I'm always looking for, but isn't necessarily reliable. And these aren't people who have been organized to write to us or to call us or doing it on their own. These are people who are called blindly and ask their opinion. And when I look at the result and see that over 70% of the citizens who were polled in this state support end-of-life options. We're only talking about an option here, an option. We're not talking about any demanded. I was fascinated to see that the North Country had something like 85%. I was really surprised that it was so high, and I don't know why, but it might have to do with the fact that they don't necessarily have access the way those of us in the southern part of the state do to a range of other services that we all value, hospice, palliative care, all of that. Gun owners, over 70% support this. And I think that's something that's really quite interesting to see. People who identify themselves as religious. They chose to identify themselves as religious. Over 60%, and that includes Protestants, Jews, and Roman Catholics. Now, these aren't people who were asked, "You are Jewish, therefore how do you believe?" And they were asked to identify themselves. And I know when I do these polls, I don't like to tell very much about myself, but these are people who chose to. So my point that I'm trying to make is that this room has people who are very caring and who have self-selected to come here. We have heard from people who have self-selected to call us, sometimes a little late in the evening, and to write to us or to email us. And then we hear from people who were just a random group who seem to think that there is merit in this. And that is why I completely understand the divergent views. I have no problem with people with different views on this or on anything else because it is the democratic way. But I think I think we have an obligation to the 70 some odd % of people who were asked and responded to a poll to give this everything that we can. I think that on this bill and on a number of other bills, this committee's been rushed to make a decision before we've necessarily had an opportunity to weigh all the pluses and minuses. And I would put this bill on that list and think I'd like to take a little more time, particularly because we have seen that there's a lot of interest out there in the state on this. And the one thing we all have in common is that we were all born and we will all die. So this affects everyone. Thank you, Mr. Chair.
Thank you. Is anyone who hasn't spoken on the committee that wishes to be heard? All right, so what I'm going to do then is I am going to delay a vote on this matter because I think that Representative Smith and Representative Turner, I agree with their position that we really can't. I speak as someone who is a supporter of this bill. I make it clear that I'm a strong supporter of this bill. Could it be made better with some amendments along the lines of what we've talked about? I think it could, and I think we have an obligation to try to do that. I understand that there are some people on the committee who no matter whose view is that they could not support this bill regardless of the amendments, and I completely understand that and respect their view on that. But I don't think that there is a reason that this bill needs to be postponed, for interim study or something like that. The amendments that I'm talking about are not particularly significant in the overall scheme of things. As I understand it, although I was never involved in this bill in my first term as a legislator, my understanding is that this something like this bill has gone through the legislature before, and if people want more details on that, I would refer to people who have been in the legislature longer than I have, and were on this committee in earlier terms. But I guess what I'm saying is, we are not. This isn't the first go around on this bill, and there may need to be a few amendments, but I think they're relatively discreet. I think we can get them done. Hopefully we can get them done. It's on the schedule to be for the continued executive session next Wednesday afternoon. If it turns out that the amendments are more complicated than we thought or something, it's possible we could end up rescheduling that to, I guess it would have to be 2 weeks later because we're not going to be sitting the week of school vacation. But at any event, I feel quite confident that we can have a vote on this bill at least by early March. So for that reason, I'm not going to take a vote on this bill now. So then next what I'd like to do is go on to our other agenda, and I'm going to turn to House Bill 1412, dealing with court reporter deregulation, and recognize Representative Kutab for a motion.
I move OTP.
Is there a second?
I'll second.
All right, Representative Kutab, would you like to speak to your motion? Or would you like me to speak to it? Whatever.
I'll just be really short on it. I'm not sure the need, since we don't have court reporters inside of the court anymore. I'm not sure the need to license it. They're being used privately by private attorneys, and I think the private attorneys can evaluate the people that we're using. They flat out told us themselves that there are no more court reporters inside of the court. So I think we're licensing something that's being used privately, and that it can be handled privately and doesn't need a public license. Thank you.
All right. Any other people who wish to be heard? Oh, yes, I'm sorry, Representative Smith, I'm sorry.
Okay, thank you very much. I wait to be asked. I'm interested to hear what the maker of the motion said, because I happen to think she's terrific. But the argument that if they're not in the courts, we shouldn't be involved kind of doesn't make any sense, because to me, unless it can be explained, we license a lot of people who are not in the courts. We license people who cut hair. We license teachers. We license all kinds of people. The fact that they're not in the court is irrelevant. They provide a service that is relied upon in the judicial process. And as for me, I'd like to make sure that they're people who are trained and qualified and follow particular standards, and so that I know that their certification of particular procedures is valid. So while I completely respect the maker of the motion, I just have to disagree on the conclusion, and I would vote against this motion.
Anyone else wishes to speak? Representative Turner.
Yeah, just one thing that I came away with from our hearing was the folks that would be, I think, given relief by removing this licensing process and licensing requirement, the process they have to go through and the fees that they have to pay. We're all here in support of continuing that license, my understanding. I think I even asked, is there anyone that they know of that from their constituent group that might feel that they should that this should be done away with? And they said no, and anyone who's being excluded from the profession because of the licensing requirement didn't come before our group to explain that. So I don't understand why we would get rid of a licensing requirement that nobody's advocating for us to not have.
All right. Anyone else wish to be heard on it? So I guess I would just, I have some sort of long history on this, and I won't bore you now with the details of the long history. But what I would say is this: all of the arguments that you heard by the people who testified in support of continuing to have regulation of court reporters, all of those arguments were the very same arguments that were made to the Supreme Court back in 2004 and 2005 for why the court system should not eliminate using court stenographers. We had the record will be, the record will not be secure. There will be, it'll be terrible. We need the court reporters, and I have to say, as I said, I want to get into a lot of detail. I was one of the judges on the Superior Court who agreed with those arguments. I would have been, 20 years ago, I would have been saying the same thing that we heard from Representative Shurtleff about This is terrible if we get rid of the court reporters. The record will not be accurate. We can't just use people monitoring tape recorders. It'll be absolutely awful. And I thought the Supreme Court was just, this was going to be a catastrophic mistake. The reality is I was wrong. The court system you replaced the court reporters. In fact, they brought a lawsuit. It went to the Supreme Court. It was a 3-2 decision in the Supreme Court with substitute judges long before I got to the Supreme Court. It was a big deal. But in fact, the reality is that having non-licensed court monitors who run the tape recording machine in the court system, and the tapes get electronically sent to an outfit in Arizona. They've been using that for years. I just recently checked with the clerk of the Supreme Court to make sure they were still using the same outfit. They send it to an outfit in Arizona, who does the transcripts. It works fine, and it saved the judicial branch a substantial amount of money. There is no reason for the state to continue to be involved in the regulation of what we could, if we wanted to be accurate, we would say this is a bill regarding non-court reporters, because they don't do anything in the court anymore. So the analogy I would ask you to draw is continuing to regulate the court reporters would be like, suppose that we said, well, Major League Baseball players don't have to be licensed. But if you're playing in the minor leagues, you got to have a license. I think most people would say, why? Why does that make any sense? If we don't, the continuing licensure of court reporters, it seems to me, it is simply a matter of sort of trying to eliminate competition, trying to prevent people who would do outside of the court essentially what we refer to now as the court monitors, the people who use the tape recorders, do inside the court. Prevent them from doing that. And right now, under the law, they are prohibited from that, because they can't, if they try to provide court reporting services, it's actually a crime. It becomes a Class A misdemeanor. It's, as much as I love and respect the court reporters, I think that was, we all in the court system at the time, on the Superior Court at least, we all we felt terrible for what happened to the court reporters. But the reality is that there is no legitimate reason for continuing to regulate them. If they want to have their certification, they can still, there's a National Association of Court Reporters, they can still, tell prospective lawyers that might want to use a deposition, someone for a deposition. I'm a member of the National Association of Court Reporters. I've been certified by them. And maybe lawyers will say, that's what I want. But there should be no reason that somebody says, who's willing to provide those services, perhaps for less money, by tape recording the deposition, shouldn't be able to do that if they want to. So that's. I'm sorry I've spoken longer than I intended to, but that's why I think we ought to OTP this bill. Yes, Representative Stapleton.
I was originally opposed to this, feeling that we were pulling the rug out from underneath these people who do a fine job in what they do, even if it's outside of the court. And I thought about it a long time, and, technology is replacing the need and the function. I'm a railroad guy. I used to be a member of the Order of Railroad Telegraphers. Well, if you could find a telegraph key in a railroad environment anymore, they'd be doing something, probably a museum. So, all industries and crafts move forward with technology. That's the basis of improvement. And professional associations, industrial associations will fill the gap that certification withdrawn will leave them. So I'm good with the the OTP.
Anyone else wish to be heard? Yes, Representative Vellante.
I just want to say that I think, first of all, their licensure is very important because there is not many court reporters that are out there anymore within our state. And the ones that we do have, they need to be valued. And I think at the same time that it's very important. Yes, technology is great, but at the same time, they have actually gone to had education within this to do that. And it's just like anything, doing away with jobs. You think about it, it's their livelihood. Some of them have been doing it for 35 years. Some of us that came to testify. So I think we really need to think about it strongly when we make our decision. Thank you.
All right, anyone else wish to be heard? Yes, Representative Manos.
Thank you, Mr. Chair. I just wanted to point out the fiscal note says that the impact is expected to be less than $10,000 in each of the fiscal years from 2024 through 2027. So whatever the impact is on the court system, it's less than $10,000 a year. Now, it doesn't specify a more specific dollar figure, so I don't know whether it's closer to the $2,000 range or the $9,000 range.
I don't have.
But it seems that at least the fiscal impact on the court is fairly insignificant.
All right, Representative Horta.
It's not on the court.
Well, I'm inclined to leave the law the way it is. There's obviously here in Congress, there's certain hostility to professional licensure in general, but I think there's still some value into having licensing, and perhaps we may even need more regulation of these companies which transcribe the recordings, because we certainly, like, we have another bill in this committee which hinges a lot on like what's on court transcripts. So there's some value, I think, in making sure that even if we are sending them off to Arizona or wherever to have these things transcribed, that they be properly transcribed. So I think we'd be losing something by just eliminating this license, even though it is a profession that's on its way out. The time may have passed it by, but I think it still has its place. So I'm going to be voting against the ought to pass, which I guess is what the motion will be.
All right, Representative Smith.
Thank you, Mr. Chair. I just want to make one correction. It would not be the court that would have less than $10,000 a year in each of the future fiscal years. It's the Office of Professional Licensure and Certification. That's where the licenses are processed, not in the court.
Anyone else wish to have anything to say on this bill? All right, I think we're ready to call the roll. The motion is OTP.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Katab votes yes. Rep. Perez.
Yes.
Rep. Smith.
No.
Rep. Horrigan.
No.
Rep. DiLorenzo.
No.
Rep. Kenny.
No.
Rep. Page.
No.
Rep. Devine.
No.
Rep. Lanza.
No.
Rep. Manos.
No.
Rep. Tur.
No.
Rep. Ming.
No.
Chairman Lynn.
Yes.
Motion fails 10 to 10.
Is there another motion?
Well,
Hey,
I'll make a motion of ITL.
is there a second? All right. Any further discussion? Seeing none, I guess we're ready to call the roll on ITL.
Vice Chairman Wallace.
No.
Rep. Alexander.
No.
Rep. Andrews.
No.
Rep. Testerman.
Yes.
Did-
Excuse me, it should be no.
No. Okay. Rep. Stapleton.
No.
Rep. Tripp.
No.
Rep. Greason.
No.
Clerk Katab votes no. Rep. Perez.
No.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Kenny.
Yes.
Rep. Page. Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep Tur,
Yes.
Rep Ming,
Yes.
Chairman Lin.
No.
Motion fails 10 to 10.
All right, so it'll go on the calendar without recommendation. All right, and Representative Katab, could I ask you to write the report for the OTP? And how about for ITL?
Anyone interested in? I'll do it.
Okay.
He's not up to what? Oh, no, I don't do that. I don't twist arms. Nobody's hand went up, so.
Next
We
up,
don't do that on our side of the aisle. Really?
uh,
At least I don't do it.
next I'd like to turn to CACR 12, and I'm going to recognize myself for a motion. I have an amendment which I think has been passed out to everyone. Has everyone? Does everyone have it?
I have not seen it. It might just be that I've missed it. Has anyone else seen it?
We had passed it.
It's where?
Oh, I'm sorry. So these are extra copies, but I thought it got passed around to everyone. It's 0524H, right?
No, I have not seen this.
I'm sorry. I thought I sent this out the night before last. Yeah.
We would like, am I the only one who doesn't have it? Do you have it? Thanks. Oh, well, okay, everybody, okay.
Where you'll see that the
Wait. So you made the motion for the adoption of the amendment. Who seconded that?
Right.
Was that Rep Wallace? Did you second?
Sure. Okay.
Would you like to explain it to us, so we
Sure,
don't have
yes.
to read the
No,
whole thing?
No, absolutely. So you may recall that Representative McGuire had the original bill was to change the definition of cherish from what it meant in 1784 to what it means today. And the purpose of this amendment is, as I think I may have mentioned at the hearing on this, I understood the intent to just be very candid with due deference to Representative McGuire, who I like a lot. I thought it was just a little too cutesy. I mean, one of the main reasons that I thought that was that the definition of cherish in 1784 is not all that different from the definition of cherish today. It's a little bit different, but not much. And what it seemed to me, what the purpose of the entire purpose of the constitutional amendment was, to basically say, to overrule the Claremont decision and to essentially say to the Supreme Court, whatever you thought cherish meant based on the 1784 definition, it doesn't mean that anymore. And so it's time to overrule Claremont. I just felt, rather than be sort of cutesy about it, why not just draft an amendment that basically says that that's what you're doing. And so the language that I propose to add to CACR 12 says this: provided further, however, that the duty to cherish the interests of literature and the sciences and all seminaries and public schools does not require the state to provide funding for public or private schools or other educational institutions at any particular level. The legislature shall have exclusive authority to determine the amount of such funding, the purposes for which such expenditures shall be made, and the sources of funding thereof, including the extent to which counties, towns, cities, and unincorporated places shall contribute funding for these purposes, and no court shall have jurisdiction to review, set aside, or modify any decisions made by the legislature with regard to these matters. So that, I mean, that's basically, that sort of says what I think the law was before Claremont and what I think the law should be today. Yeah.
I would like to congratulate the chair for being absolutely and completely honest in this amendment. And I too like Representative McGuire, and we have worked together on many issues, not exactly this one, because I happen to believe in 3 branches of government: legislative, executive, and judicial. Even though the judicial branch now does not happen to have the benefit of the former Chief Justice, there are other moderately competent people in the judicial branch. And I also believe that there is nothing that is more important in a democratic, small d, democratic society than public education. I could not possibly support any amendment that removes one branch of the government from something as important as public education. And I would suggest on this one, Mr. Chair, there's probably no need to have extensive debate, because I think we can probably predict what is going to happen on the vote, and we might as well just go right ahead to the vote for those people who don't believe that the judicial branch should have any role in protecting access in a democratic society to public education, and those people who do. And we'll vote, and then we'll go on from there, and probably no positions will be changed. Thank you.
Anyone else? Yes, Representative Grease.
Just for the record, we have a republic, small r, form of government that uses democratic principles, small d, but that's all. Just point of contention.
Other, anyone else? Yes, Representative Stapleton.
Yeah, thank you, Mr. Chair, and thank you for bringing forth this amendment. I was uncertain as to how to parse this out and where to go with it, but if we look at the Conval and the Rand lawsuit decisions, they squarely put the obligation for the matter into the legislature. And this amendment states that. So I thought we brought 2 maybe opposing sides somewhat together with the amendment. Thank you. And I'm good with the amendment.
All right. Anyone else wish to be heard? Representative Horrigan.
Well, I guess Reverend Smith pretty much said it all, but that last sentence, I totally don't see how that could work. I mean, I guess a constitutional provision can't be unconstitutional, but I'm not sure how, given what we say about the courts and the rest of the Constitution, how we can shut them out of that one subject area. I mean, we've had the Claremont decision and the other ones, but the problem with that, it's not really the court's fault. The problem is the legislature has been refusing to follow the Constitution. And also, if you're talking about funding for any level, that's kind of strange, but also like you're leaving out of course, you're leaving out the education freedom account or school voucher providers. So we're not, although I guess, so we're not going to be obligated to fund that program either if we pass this constitutional amendment, which, I mean, that doesn't necessarily bother me personally, but I think this amendment, it's interesting, but I don't think it just totally doesn't work for me, especially that last sentence. That's going to create massive confusion. And finally, I'm sort of pleasantly surprised, at least, that they wanted to stick with the 2024 definition of cherish. Usually when they talk about how people thought of things in the 18th century as well as the 21st century, it's because they want us to go back to the 21st, to the 18th century. So at least that part of the debate is somewhat encouraging, but I'm still like, I'm still not supportive of this amendment at all. So, but it's very interesting though, but thanks.
All right. Any other comments? Representative Devine.
I'm almost afraid to say it, but don't we open the door to when we start playing cutesy with, passing potential bills like this and changing words like cherish and then just bringing them up to date? Couldn't one, later on turn around and bring another bill forward, say with the right to bear arms, and say this phrase does not jive with what people want to happen now, so let's change it now and make it more of what's politically correct in 2024 as opposed to what was politically correct in 1776 or whatever. Why would we be looking at that? That's where I'm kind of having a problem with this. This is a play on words, and I don't think we should be even addressing it in this room. That's where I stand.
Okay. Anyone else wish to be heard? Yes, Representative Tuttle.
So I really don't like that the initial bill wasn't more clear on what the intent was. And I do like that the amendment is clear on the intent, on what the intent is. I don't think that it's fair to put something potentially out to voters that they're not going to understand what it even means when you're putting something out there. I mean, I can't imagine getting this as a voter and seeing, okay, we're going to change the word cherish to cherish. Voters are going to be so confused going, why are we changing a word to the same word? So I do like that the amendment makes clear what the intent actually is. However, I think that we've always kind of valued education, and I'm not sure that I like that it's solely leaving it up without anybody being able to oversee it. I'm not sure how I feel about it, but I do like that the amendment is kind of more clear on it. And I guess I'm kind of a little bit unsure where to go on this one. Thanks.
Anyone else wish to be heard? Representative DiLorenzo.
Thank you, Mr. Chair. This is confusing. The bill is confusing. The amendment is a little bit more clear. But when the Secretary of State draws up the question on the ballots, what exactly is it going to say?
So it's on there. It's in the bill, what it will say.
Right here. I don't see it printed out. Okay. Oh, I see. Okay, so that's it. That's fine. Thank you.
Anyone else wish to be heard? So, the only other thing that I would say on this is, and I understand both Representative Kutaba and Representative Smith's point about the court. My problem is, and this really is the heart of the Claremont matter. If we don't do something like this, this will never end. The important thing, I think the most disturbing part about Claremont is that by creating this sort of affirmative right, this affirmative constitutional right that anybody can exercise, the funding thing will never end. There's this litigation now. It'll go to the Supreme Court. The Supreme Court will do whatever they let's assume that the Supreme Court affirms the trial court and says, I think what it was, $7,000 per student or something is what a minimum request. That'll be good until somebody gets the idea that we should be spending more, and then there'll be another lawsuit, and it'll go on and on and on, and that's why it just seems to me the legislature is the body that is elected and representative of the people and should be the ones that make these decisions. That's why I think this is important. But anyway, understand, this is, as I've said to my caucus, I say it public, there's been, nobody in leadership on my side of the aisle has been sort of trying to strong arm anybody on this. So I encourage all of you to vote your conscience on this.
Mr. Chair, can I say one quick
Sure, absolutely.
to Representative Di Lorenzo's point? I don't know if it matters, but in the amendment, the new language on the final page that inserts your language from page 2 isn't bolded. So I don't know if the amendment is fully clear that it's also adding that in what would be on the ballot.
That's a good point. I think from my understanding of prior constitutional amendments that they generally don't. On the ballot itself, they wouldn't put that in. I think that's the way they typically do it.
Okay, I was just questioning
Sure.
the form of the amendment, not the content of the amendment.
Right. No, I hear you. All right. Anyone else wish to be heard? All right. So I guess I would ask the clerk to call the roll. Oh, well, we can do it by on the amendment.
Let's call the roll on the amendment.
Okay. All right. Sure.
that's
That's
okay.
fine. Nope. That's fine.
All right, so on the emotion of adopting Amendment 0524H, Vice Chairman Wallace,
Yes.
Rep. Alexander,
No.
Rep. Andrews,
Yes.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Katab votes yes, Rep. Perez,
Yes.
Rep. Smith,
No.
Rep. Horrigan,
No.
Rep. DiLorenzo,
No,
Rep. Kenny,
No.
Rep. Page,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Tur,
No.
Rep. Ming.
No.
Motion fails 9-11. Oh, whoops, sorry, Chairman Lynn. Sorry, Chairman Lynn.
That's all right. Yes.
Okay.
All right.
So motion fails 9-11.
Okay. And then, yes.
I would like to make a motion on CACR 12.
Yes.
Oh,
That's a good question.
that, Representative Greason, that's interesting. I would have to check with the clerk on that because we were really voting only on the amendment.
Right.
And
If I can help too, I think members may want to change their vote between the amendment and the actual underlying bill as well.
Right.
Representative Alexander, so what do you mean by that? So you would like to go,
I think we should have a full vote on the OTP motion.
Yeah. No,
I'm
I
happy
think-
then to
yeah.
withdraw my, I'm happy to withdraw my motion if you want to go straight to OTP.
On the original.
Then it would have to be
Right,
original. That's the
right,
only thing
right.
before us.
Yep, and I know, I think I understand where Representative Alexander's coming from, because I think some people that voted for the amendment might not be voting for the OTP on the underlying bill. All right, so can I ask you to call the roll, please?
On the motion of OTP, Vice Chairman Wallace,
Yes.
Rep. Alexander,
Yes.
Rep. Andrews,
No.
Rep. Testerman,
Yes.
Rep. Stapleton,
Yes.
Rep. Tripp,
Yes.
Rep. Greason,
Yes.
Clerk Katab votes no. Rep. Perez,
Yes.
Rep. Smith,
No.
Rep. Horrigan,
No.
Rep. DiLorenzo,
no,
Rep. Kenny,
No.
Rep. Page,
No.
Rep. Devine,
No.
Rep. Lanza,
No.
Rep. Manos,
No.
Rep. Tur,
No.
Rep. Ming.
No.
Chairman Lynn.
Yes.
Motion fails 8 to 12.
All right, now do we have,
Mr. Chair, I'd like to make a motion.
all right, yes,
I really don't want to make a motion, but I'm going to. Mr. Chair, I would move ITL on CA CR 12.
is there a second? Second by Representative Kinney.
Who seconded?
Representative Kinney,
Thank you.
any further discussion? All right, then I think we can call the roll on the ITL.
Vice Chairman Wallace.
No.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
No.
Rep. Greason.
Yes.
Clerk Katab votes yes. Rep. Perez.
No.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes. And
Rep. DiLorenzo.
Yes.
Rep. Kenny.
Yes.
Rep. Page.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Ming.
Yes.
Chairman Lynn.
No.
Motion fails 16. Motion passes 16 to 4.
All right.
I will write the report.
All right.
And
Smith. And I guess if there's going to be a minority report, I will write it. I'm not sure that there will be or not, but unless somebody else wants to write the minority report. Not seeing anyone. Okay. All right. Yeah. All right. Let's go to 1169, discrimination based on hairstyles. And do I have a motion on that?
I'll move OTP.
I'll second.
who was that? Was that DiLorenzo?
Kutab.
Oh, Kutab, okay. Kutab and Lynn,
And
On-
Kutab and Lynn, yeah.
OTP on 1169.
Representative Kutab, do you want to speak to your motion?
No, that's okay.
All right. Anyone? Yes, Representative Alexander.
Thank you, Mr. Chair. I have a huge problem with this bill. I think that the Human Rights Commission has this right when they say that when you add more language, it actually does a disservice to people that are being discriminated against by adding more specific language than leaving the whole ethnicity. I think the Human Rights Commission is right, so I'm definitely voting against that motion. Thank you.
All right. Anyone else wish to be heard? All right, then I'd ask the clerk to call the roll, please.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
No.
Rep. Andrews.
Yes.
Rep. Testerman.
yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
No.
Rep. Greason. Oh. Clerk Katab votes yes. Rep. Perez.
Yes.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Kenny.
Yes.
Rep. Page.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Ming.
Yes.
Chairman Lynn.
Yes.
Motion passes 17 to 2.
Can that go on consent? Anybody have an objection to it?
Yeah, can we leave that on the regular calendar, please?
All right. yeah,
Thank you.
Regular. We ready a minority report?
I'll write a minority report. Thank you.
So who wants to write the majority report? Can I
Again,
solicit?
I'm a co-sponsor. May I still
Oh,
do
of
it?
course, yes.
Okay,
All
yes, I will do it.
So,
Thank you.
all right, so majority will be Representative DiLorenzo, and the minority will be Representative Alexander.
Moving right along here.
All right, next, House Bill 1220. And I believe, Representative Ming, you have an amendment, is that correct? So do you want to move your amendment?
Okay, yeah. So the amendment is 2024-0415H, and again, this is to, the initial bill is to remove the collection of.
So we know, I'm just, so you move your amendment, is that?
I move my amendment. Okay,
Is
sorry.
there-
Yes, and then second.
Is there a second?
Mr. Chair, just a point of clarification, the motion is OTP and he's moving an amendment. right?
OTPA, yeah.
Thank you.
Right.
That's, I just.
I
wanted to
move ought to pass with amendment 2024-0415H.
All right, and is there a second?
I second.
What?
Yes, it was distributed, I believe, but
There are additional copies, so.
Yeah, it was distributed. I think it was distributed quite a while ago. I'm sorry, who made the second on that?
I did.
You, okay. All right, I'm sorry, Representative Ming, do you wish to speak to your amendment?
I can just do it really quickly.
Sure.
So again, the underlying bill is to remove the collection of race and ancestry from marriage applications. And the amendment is to additionally move the level of education. That's pretty much it.
All right, anyone else wish to be heard on the amendment? Yeah, all right, oh, yes, Representative Perez.
I just want to say that, once again, I think for future generations, it is important to have the ethnicity on the marriage certificate so that when they look back, when names have changed over and over and over again, and they have no idea, when they look back, they can see where their relatives came from, because a lot of things come up later, or I think for medical reasons, if nothing else, it should be on there.
All right, anyone else wish to
Mr.
be?
Chair?
Yes.
Yes,
Representative Lorenz.
I don't think it's really necessary to have the ethnicity on the ancestry on the marriage report, because DNA is widely available for everyone. Thank you.
Anyone else wish to be heard? All right, so this is going to be a vote on the amendment. I would propose to do that by show of hands unless somebody objects. All right, so show of hands then. For those in favor of the amendment, please raise your hand. Those opposed? All right. I'm sorry, we have two, so it's Representative Andrus and Representative Perez are opposed. So what, 17 to 2, all right.
Wait, no.
Alexander's
Alexander's not in the room.
Oh, I'm sorry, I didn't see him leave.
Sorry, 17 to 2. All right, so now we're on to the main motion of ought to pass as amended. Does anyone wish to speak further on the motion of OTPA? Seeing none, I would ask the clerk then to call the roll on the OTPA motion.
And that was moved by Rep Ming and seconded by Rep Smith.
Yes, yes, it was.
Thank you so much. Vice Chairman Wallace?
Yes.
Rep Andrews?
No.
Rep Testerman?
Yes.
Rep Stapleton?
Yes.
Rep Tripp?
Yes.
Rep Greason?
Yes.
Clerk Katab votes yes. Rep Perez?
No,
Rep Smith?
Yes.
Rep Horrigan?
Yes.
Rep DiLorenzo?
Yes.
Rep Kenny?
Yes.
Rep Page?
Yes.
Rep Devine?
Yes.
Rep Lanza,
Yes.
Rep Manos,
Yes.
Rep Terror,
Yes.
Rep Ming,
Yes.
Chairman Lin.
Yes.
Motion passes 17-2.
All right. Can that go on the consent calendar? Anyone object to it being on consent? All right, so it'll go. Okay, all right, no, they'll go on the regular calendar. All right. Regular, all right. All right, so Representative Ming, will you write the majority report?
Yes.
And Representative Perez, you're going to write the minority? All right. All right. So what I'm going to do on House Bill 1432, I think I'm going to recess the executive session on that because I think we're basically in the same position on that bill as we were on 1283. There are some amendments that have been sort of bantied about. I mean, nothing's been filed yet, but there have been some amendments that I think ought to be considered before we have a further discussion on the bill. And so that I'm going to recess the hearing on that, and we'll take that up next Wednesday if we have time, and if we don't have time then because we're too busy, then we'll move it over to after that. But I think that's really an important bill, and I'm hoping. I know that there've been some people have expressed an opposition to the bill initially, but I'm hoping that maybe with the amendments we may be able to come to more of a consensus on it. Then next I'm going to turn to House Bill 1475, and I guess I'll recognize myself with regard to that and move inexpedient to legislate. Is there a second?
I second.
All right, seconded by Representative Kutab. And so let me just state briefly as I can why I think ITL is the appropriate. The person who testified about these SLAPP lawsuits, I believe he was an attorney from Massachusetts, was obviously very knowledgeable in this area, and apparently has drafted these kind of bills for other states. I looked at the bill. I looked at the bill very carefully, and I know I asked Representative Page if he had a chance to look at it, if he would have a chance to look at it, and what his impression was, and I'm going to ask him about that in a minute. But my impression about the bill was that although there was talk about this making substantial substantive changes to the law, it really doesn't. If you look at the bill, what it essentially does is in lawsuits that might be characterized as being brought against somebody, either as a claim or a counterclaim, to try to prevent them from exercising their rights of expression. All this bill does really is to say that in those kind of cases, there can be kind of an expedited motion to dismiss and a requirement that the plaintiff in those kind of cases come forth with its evidence, if you will, at an earlier stage than might otherwise be the case under the normal rules of the court. It doesn't change in any way the substantive law. And so, is that a particular value to be able to resolve cases more quickly in some circumstances? Arguably. But the problem is, we didn't really hear any evidence that this is a problem in New Hampshire, that people are bringing, these kind of lawsuits to stop public participation in New Hampshire. I didn't hear any evidence about that. In the time that I, spent as a judge, I didn't see that this was, I'm not saying that there was never a case like this. I don't know. I can't remember one offhand, but it certainly wasn't something that was sort of, an epidemic that requires some specialized procedures. So for those reasons, I just think if it ain't broke, don't fix it. That's. But Representative Page, I asked you if you have a different view, I'm all ears.
So, as a former elementary school teacher, to say I didn't do my homework very well, I will say that now. My initial sort of 30,000-foot view where there may have been some sort of jurisdictional issues in terms of state claims in federal court.
No, you're right.
So
The
there
Fed
was
is a real issue.
that
there.
issue with this that I'm not sure has been resolved. So, but I concur that I don't see this as a necessary action, if that's what I'm understanding you saying. Mr.
Right.
Chair.
No, and you raise a very valid point. There's some language in there about what the federal courts would have to do that I'm not sure would be constitutional under the supremacy clause. But that's another issue. But I think the main reason for me is I just don't see that this is necessary. Anyone? Yes, Representative Perez.
I just want to say these things are happening. Maybe they didn't when you were on the bench, but these things are happening, especially in small towns, that lawsuits are being pushed against people. And I think this is not the wording perhaps, or it needs to be redone, but we do have, people that are, municipalities are going after people and putting things on them for no justified reason, so.
All right. Anyone else wish to be heard on this? All right. Then the motion is ITL, and I would ask the clerk to call the roll, please.
Vice Chairman Wallace,
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Katab votes yes. Rep. Perez.
Yes.
Rep. Smith. Yes. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Kenny.
Yes.
Rep. Page.
Yes.
Rep. Devine.
Yes.
Rep. Lanza.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Ming.
Yes.
Chairman Lynn.
Yes.
Motion passes 20-0.
Consent. Consent. All right. And I will write the report. All right. Next. 1412. You and Katab, I think. Yes. That's right. All right. On House Bill 1603, this is the bill that would, I guess the intent was to prohibit municipalities or local governmental bodies from passing laws that would prohibit women from being topless where men were allowed to be topless. That if I recall from Representative Hines' testimony, that was the basic purpose of the bill. As you may know, there was a Supreme Court decision that said that it wasn't unconstitutional to do that. Do I have a motion on that bill? Anyone want to? All right. Well, then I will.
Draws the short
What?
straw.
All right, motion ITL. All right, is there a second?
I second it.
All right, second. All right. All right. Representative Stapleton, do you wish to be heard at all on your motion?
Well, I got a note here, problematic and unintended results, and maybe when we have, like in 396, enabled separation by the sexes, this might be running contrary to that and creates a problem. So I'm ideal on it.
Anyone else wish to be heard on 1603? Yes.
Well, two good reasons. ITL, one is it goes far beyond, of course, I was not at the hearing, but it goes far beyond what apparently was now former Representative Hines' original intent, but also the way it's worded, I'm not, usually these, well, it's probably in the wrong committee too. It probably should have been in municipal and county government, but that's fine. We can handle it. But the talks about the unincorporated places, they can't do anything on their own. The county government stands in place of the unincorporated place. And usually I think the language probably been more appropriate as a political subdivision, because that also takes in the school districts and village districts, which might also want to discriminate against people on the basis of race or sex. So like aside from the fact, I think the basic idea is not a great one. It's, even if you liked the idea, it's not really a well worded way to do it. So
All right.
thanks.
Anyone else wish to be heard on this bill? All right, then I guess we're ready to call the roll. The motion is ITL on House Bill 1603.
Vice Chairman Wallace.
Yes.
Rep. Alexander.
Yes.
Rep. Andrews.
Yes.
Rep. Testerman.
Yes.
Rep. Stapleton.
Yes.
Rep. Tripp.
Yes.
Rep. Greason.
Yes.
Clerk Katab votes yes. Rep. Perez. Rep. Smith. Rep. Horrigan.
Yes.
Rep. DiLorenzo.
Yes.
Rep. Kenny.
Yes.
Rep. Page. Rep. Devine.
Yes.
Rep. Manos.
Yes.
Rep. Lanza.
Yes.
Rep. Turer.
Yes.
Rep. Ming.
Yes.
Chairman Lynn.
Yes.
Motion passes 20-0.
Consent and all right. And Representative Stapleton, could I ask you to write the report? Thank you. That's it. That's probably right. Yes. All right. Next, I'm going to turn to House Bill 1037, and I recognize Representative Turer for a motion.
Thank you, Mr. Chairman. I had distributed an amendment to this bill. It is 0698H, and I'd like to make the motion to OTPA 1037 with that amendment.
All right. Is there a second? All right, seconded by Representative Smith.
Is it 713?
Yeah, it's a 1037 is the bill and 0698H is the amendment. I sent it around in paper form and I emailed it yesterday, but I have extra copies of that if anyone needs it. Hang on.
All right. Representative Turer, would you like to speak to your motion?
Yeah, that's probably a good idea. So this amendment actually modifies the bill very significantly. It basically takes out the main clause of the original bill and replaces it with modification to the language that essentially only changes two words in the underlying law as it stands, which seems fairly minor, but it does have real implications and I think benefits for the way that this works currently. I will say the reason for this. As we went around the discussion, there was a statement that that the idea that an organization, manufacturer, dealer that hasn't committed any crimes should not be pierced in this immunity. I will say there's a lot that could be said. I'm going to try and avoid saying most of it, but we'll answer questions. There was the Chester Arms case Supreme Court settlement just a couple of weeks earlier than this hearing that spoke that modified or at least clarified some of the clauses in the provision that this was relating to, and I think in a nutshell, the thought behind this is that the way it stands right now, a civil liability case brought can be only pierced using results of a completely different case, which would be a criminal proceeding against the manufacturer or a dealer of the weapons. So there would have to be a criminal case brought and a criminal case decided, and then the results of that would have bearing on whether a civil case could be brought. And basically the change from the language of convicted of to that committed brings the requirements to understand whether or not those entities committed an underlying felonious act would be heard as part of the civil suit rather than hinging on an external lawsuit that's not really part of the civil proceeding. And I will say, I will give deference. I'm not saying, I want to make clear, Representative Lynn did not say he supports in any way this, but helped think through the concept underlying this. So did OLS, that essentially when you do that, you also change the standard of proof. Because a civil proceeding has a preponderance of evidence standard, whereas a criminal proceeding has a beyond a reasonable doubt standard. So it's not saying that you don't have to have committed a felonious act in order to pierce this immunity. It puts the standard in alignment with the civil proceeding that this RSA speaks to. So I'll stop there, and there may be questions.
All right. So anyone else wish to be heard? So I guess what I would say is I was happy to work with Representative Tur on the amendment because he asked, and I thought I could be helpful. But what I would say, and I say this very strongly, is Representative Tur makes what, in my view, is like a completely horrible bill into only a very bad bill. And it does make a very significant change in the law, because as he said, it would significantly weaken the firearms immunity statute, because it would, instead of having to have a conviction that's already in place beyond a reasonable doubt, this would allow somebody to prove in the civil case that there was a crime, that the dealer committed some kind of a crime. This, I can't emphasize strongly enough, with or without the amendment, this bill is the beginning of a death knell to the firearms industry. So I urge people to vote against the amendment and then against the underlying bill. Representative Stapleton.
Thank you, Mr. Chair. I have difficulty getting my head around that in spite of good attempt by my colleague to explain it. I got the difference between a civil and criminal liability, but I'm still puzzled as to why that those are connected in this instance. Example might be helpful, but I can't conceive of one. I just, because I don't understand it, I can't vote for the amendment without a lot of additional thought, and I haven't got the time for that, so I've got to oppose the amendment.
All right, anyone else wish to be heard on the amendment?
I have to agree with you, Representative Lynn. This is a backdoor. I've been saying it all along, and you talk about, I had over 400 emails against this bill.
All right, any other comment? All right, so we're voting on the amendment only. And do we, I think we probably ought to do this by roll call
Okay.
on the amendment.
Vice Chairman Wallace,
No.
Rep. Alexander,
No.
Rep. Andrews,
No.
Rep. Testerman,
No.
Rep. Stapleton,
No,
Rep. Tripp,
No.
Rep. Greason,
No.
Clerk Katab votes no. Rep. Perez, Rep. Smith, Rep. Horrigan,
Yes.
Rep. DiLorenzo,
Yes.
Rep. Kenny,
Yes.
Rep. Page,
Yes.
Rep. Devine,
Yes.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Calling me.
sorry, Rep. Lanza,
Yes.
Rep. Ming,
Yes.
Chairman Lynn.
No.
Adoption fails 10 to 10.
Um, I re-
I don't know if we're going to vote on, are we going to vote on the underlying OTP now first?
no, that's right. We probably should, yeah, all right. So, Representative Turner, hang on.
Can can we
Yeah.
move to ITL, the initial bill?
Yeah, I
OTP.
think we have to do OTP first.
Oh, I'm-
Mr. Chair, could I ask for advice? Oh, excuse me. I got so excited there. Could I ask for advice?
Certainly, of
Is
course.
that allowed? The importance of the presence of this industry in the state is not to be denied. There are a lot of jobs. It affects the whole state economy. This is not a little fly-by-night operation. And that is very important. There are, just as there are on many bills that we have in this committee, there are difficult decisions that have to be made in terms of balancing the pluses and the minuses, the goods and the bads, and violating or dealing with what I'm going to call, no, I don't want to call it that, what kind of preconditioned positions on bills. Let me give you just one example, and I hope no one's going to groan and moan. When I first was here, the presence of the NRA was incredibly important for many reasons, including the way they contributed to the cost of so many of our colleagues' campaigns. That has now changed over the years. And it's relevant because some of our reactions are conditioned on past realities. I personally do not want to see an important industry forced out of the state. I personally believe that as a country, we have a problem with the way our firearms are available to so many people. It happens just yesterday that apparently, as part of celebrating the Super Bowl, it's important to use firearms. I know, and everyone in this room knows, that no manufacturer of firearms wants them to be used that way. I don't have any question about that. And I would imagine that in another environment, those manufacturers would be willing to stand up and say that. I think that somewhere there must be a way for us to address the problem of the misuse of firearms without hurting an important industry. I don't know what that answer is, but my problem is I don't want to vote yes on this bill. I don't think it's a good bill. And I will say that understanding that this is being taped and it can now be used against me. But there's no way that I could vote either way, I guess, is what my problem is. And so what I'm wondering is, would the committee consider the possibility of us sending this bill to interim study to see if maybe we could come up with a way that honors the importance of the industry in the state while recognizing that misuse is not in anybody's interest. I don't know if there's a way to do that, but I don't think anybody who respects the industry wants to see people at a Super Bowl, kids at a Super Bowl parade shot at or killed or whatever. And I really believe that. So is there some way that we can come up with a brilliant idea, and could we do it by interim studying this bill? Well, if a motion is possible, at this point, I've now lost track. Representative Greason's probably right on it. I've lost track of exactly where we are in parliamentary procedure. But if there were a time when I could make that motion, I would. Rather than find myself and others in a position of having to vote for a bill that doesn't necessarily accomplish what we want to accomplish. And it's a problem, and I need help.
So I guess my sense is I think we do need to vote on OTP, and then if there's an ITL motion on ITL. But the other thing I would say, Representative Smith, is I think, at least I'm speaking for myself here, I don't know if my colleagues agree, I just feel so strongly that this bill that this bill needs to die, to be candid about it, that I don't think that there's anything that I can conceive of that would persuade me to, to think that some kind of a change or amendment. And the other concern I have is I think even the fact that something other than this bill dying happens is itself sending a signal, I think, to the industry. And so while I respect very much what you say, I have to say I disagree. So I think we probably need to vote on the OTP motion at this point.
Mr. Chair, could I also just ask you another question? Is that clock right?
Yeah, we got to get going to caucus. So,
I know, we have
so can we call the question on this to get going?
We have
a call.
a caucus.
Yeah,
at
no,
noon.
so do we, so I.
So we have 6 minutes left.
yeah,
It's
so let's-
11:54.
maybe let's at least get this bill out of the way, I guess I would propose.
Okay.
Representative Hort.
Yes, I now will have 5.5 minutes. I'm a co-sponsor of this bill. There's a major gun manufacturer that's invested probably hundreds of millions of dollars in the area where I live, and I have no problem with that. And I think they would stay regardless of whether or not they move. They've had, in addition to concern about misuse of guns, they did have a product liability issue back about the time when the original law that this bill would overturn was passed. And I will say I'm satisfied that they've been dealing with that product liability issue as responsibly as they can. So I'm going to vote yes on the OTP, but I won't be shocked if that does fail, if that does not get a majority of the committee. So thanks.
Representative Kenny.
I move to call the question because we have.
So
5
that's
minutes
actually
to get-
precisely my point. I think Representative Smith has brought up a lot of good points that warrant further discussion. I've felt the vibe that we do rush through some things, and I don't know why. I don't think it's productive. I don't want to call the question when people still want to have a discussion on a bill. And I understand we have a lot to get through, but I'm uncomfortable taking a vote on this when we know members still want to have a discussion.
And I concur on that, especially on a bill this important that.
We started the vote though, and now we have to get to caucus in 5 minutes. We have a motion
No,
on
I'm
the table, and we have to
gonna-
get to
we're-
caucus.
yeah,
That's the
we're in
problem.
Yeah, no, we're gonna vote.
It's just a point of inquiry. Point of inquiry.
What, pardon?
Is it possible, I guess, and Representative Greason might be able to answer the question, is it procedurally possible someone withdraw the motion? Are we already in the process?
Can I withdraw my motion?
I think if it fails, we can, I think if it fails, then we can recess the executive session until next week. So that's, or whenever.
So,
But I don't think,
so per Representative Greason, my understanding is the motion is still my motion because there hasn't been a OTP by anyone else.
right, it
So-
wasn't seconded.
No, you can withdraw your motion of OTP. You can withdraw that. You can do that.
I don't know if that helps the cause. My
But-
goal
but-
would
but
my
no,
goal would be to continue
I want,
this.
here's what I would say is if you withdraw the OTP, we will not have a vote on OTP. The next motion will be my motion, ITL, and we will have a vote on that. So it's up to you.
I guess I'll withdraw the motion.
All right, so then I would move ITL on.
I second, Mr.
I
Chair.
second. Oh, okay.
All right, so anyone, any
Wait, who
further?
seconded that motion?
Alexander.
No, wait, who seconded?
Rep. Alexander
I
seconded.
second.
Who seconded Eric's motion?
No, nobody.
You did.
I thought I did.
Yeah.
So, and I would have to agree to it. Mr. Chair, I would like to take a recess because of the fact that all of us in this room have caucuses that start at noon. And I am not quite ready to withdraw my second of that motion. Just give us a break. Give us. I rarely ask you to give us. Give us a break. See if we can figure
Figure out a way to do, all right.
out what it is.
Okay,
Just
all
give
right,
us a-
all
We
right.
don't want it, but
Let's move IS.
Who's this guy? No, this is kind of. Oh, no, 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 no.
I'll
All
ask
right,
Paul
no,
if
no,
we
I'm
can
withdrawing
do
the
that.
motion. If you get a motion, I don't, yeah, no. I understand it, so. Let's, let's just, let's think about it. Let's just reset. I just, no, I want to, I don't want to be the guy that seconds it, but I will, because if I'm gonna move that, I'd second it, just as a friend. Gets her off the hook. Yeah, you know what the problem is, I think if we don't, my submission. No, no, I think, no, no, right. Here's the thing. I think it's gotta, I will recess this so you have more time to think of it. What I would say is, I don't think that.
I don't know if you can
our
recess when
caucus
you're in
would
the middle
go
of the vote. I'm gonna call the clerk
with
because I don't really know what
interim
to do
study
here.
because we need it to
Give me
be
a second. I'm
built.
gonna
We
call
need
the
it to
clerk
be
because I don't
built.
know if we can
All right.
recess once you've
All
already
right.
taken.
I
I'm
will-
gonna just find out.
I think we need to be because no, because what I'm saying is this. I'm more than happy to give you more time, but I think on the floor, we would kill this bill because I think on the floor, some of your people would. Right. So, yes. All right. So here's just. All right. I'm willing to take that.
Do what you
All
want.
right, yeah,
That's
no,
all.
I just, no, yeah, no,
Myself
I hear you.
to be supported.
All right. So. All right, so I think unless she tells me I can't do this, I'm gonna recess. Right, no, exactly.
That is absolutely true, but my obligation is to be here.
I understand.
I
Right.
don't think I'm not tempted to
Right.
walk out, but I won't, other people won't do that, but I won't.
Why can't we recess?
Right, no, I think that's what Representative Katsop's
Problem
checking.
is, we're in the voting mode. No, we're technically in the voting mode.
What?
That's.
So what's the? Okay.
Just go.
Look, I don't, March, I don't have to give you that time. My concern is just that I don't think it's gonna change. Even if it's interim study, it's gonna get. No. If I'm gonna, unless Paul Smith tells me I can't recess, I'm gonna recess. Because I don't, I don't like the idea of sort of forcing people to. So you know what, listen, I'm, well, if we, so, no, so you know what, here's what I'm gonna do. I'm gonna recess the committee meeting. If we're told that we can't recess, I assume that the only thing that would mean is that we have to vote over again on the motion of the amendment on your motion to amend. And so we presumably, I don't think anybody's gonna change their mind. We would have the same vote again. So I sort of feel like no harm, no foul. So I'm gonna recess. Thank you all. I'm sorry I kept you over the line, but now just one other thing before we go. Those of you who are gonna write reports, could you get the reports to me by the end of the day tomorrow? All right. Thank you. Thank you.